Hi, I'm Adam Dobrinich, Bay Area real estate agent and certified probate and trust specialist. Today I'm going to be talking about the difference between a power of attorney and a personal representative in a probate process. Now, full disclaimer, I am not a licensed attorney. These are just some of the best practices and examples to keep in mind and an overview of steps that you can take. It's purely educational with the goal in mind of helping you to make sound real estate decisions. If you have questions, consult with an attorney. If you do not have an attorney, please feel free to reach out to me. I can certainly refer you to some of the attorneys that I can work with so that you can ask some questions and interview them to see if they are a good fit for you and your situation, or reach out to a local attorney to provide you guidance and legal counsel. All right, so with that being said, let's jump into the difference between a power of attorney and a personal representative in a probate process. So a power of attorney is going to be set up for somebody who is still alive. This is for somebody that needs help managing the finances, getting to the next phase of life, liquidating a real estate asset, managing accounts, paying bills, entering in agreements like a listing agreement on a property. Generally somebody that needs help with their decision making and managing various aspects of their life. This is what a power of attorney is for. Now, this is very common for senior citizens who are considering downsizing or moving into assisted living, or perhaps even moving in with a family member and needs help managing this process, or needs help managing various aspects of their life as they're moving into this new phase. Again, this would be where a power of attorney might be put in place. So if this is a situation that you or a family member find yourself in, especially when you're trying to liquidate an asset like a property, you will want to have a power of attorney document drafted and notarized. And this is very important because this document is going to give legitimacy to whatever impending actions that you are going to take. So for example, if you're going to sell a property, you would give that notarized document to the title company to verify that that power of attorney was legally able to sell that property for you. And make sure that that power of attorney document clearly states what powers are given to this person to make decisions on behalf of the person that needs assistance. Again, for example, this person has the ability and is able to sell a property and make that decision on behalf of the person that needs that assistance. You will want to keep this document and other important relevant documents in a safe place. Make copies of them. They are going to be very important throughout any actions that you take on behalf of the person that needs assistance, and make sure that the person that you have power of authority for understands and is aware of the actions that you are taking on their behalf, like selling a home, or depending upon that person's mental capacity, does a court need to be involved? The most important thing here is just make sure that you are clear on these things. Now, a personal representative in probate. This is where the descendant has passed away, and the personal representative is a court-appointed administrator or an executor of the estate, depending upon the situation. This personal representative is assigned by the court after they have filed for probate and the letters of testamentary and the letters of administration have been provided, and these letters are certified by the court and give you the power to deal with the estate and deal with selling the property within the estate. Now, this power is very similar to the power of attorney, where it's very important that you understand whether or not you have full authority or limited authority over the decision-making process within the estate. With full authority, you will have the authority to make all of the decisions on the behalf of the estate. Or if you have limited authority, the court will be supervising. So for example, selling a property, it would need to go through the court in order to finalize that sale. And of course, there are some additional steps that go into that process, but it is important for you to understand whether or not you have full authority or whether you have limited authority. Okay, so these certified documents that you will get approval for from the court are very important, especially when it comes to selling real estate for the estate. These documents will need to be provided to the title company to validate that you have the authority to sell the property. As part of your team, you want to make sure that you are working with a real estate agent that has done probate sales before, that they are familiar with the process, and that they have systems in place to help facilitate this for you. You will also want to confirm their ability to work closely with your attorney to help make sure that this process is facilitated correctly and that you are being represented properly. There are going to be a lot of things for you to consider when it comes to selling a property as the personal representative of the estate. These will be things like getting a proper valuation for the property, understanding whether or not you should sell off market or if you should list it and put it on the market for a traditional sale. You would also want to understand if you should do any repairs to the property, if you should sell to an investor. These are all different kinds of considerations that as the personal representative you will need to keep in mind and having a real estate agent that has done this before and can guide you through the process and have resources that you can leverage should be top of mind for you. Again, I will reiterate the importance of talking with your attorney. Make sure you're getting legal advice and that you understand this process from beginning to end. It is incredibly important for you to do so. This will help make sure that you are making decisions in the best interest of the estate and that you are being a good fiduciary to the estate. All right, I hope you found this high-level overview of the differences between a power of attorney and a personal representative for an estate in probate helpful. If you are curious about the process of selling a property in either scenario, whether the person is living and needs assistance or the descendant has passed away and it's time to consider selling a property in that probate process, please reach out to me. My calendar is always available to you. I'm happy to talk through your scenario. I will absolutely take the time to understand your specific situation, understand the needs that you have, and make sure that your questions are answered. If it is something that I cannot answer, or if you are in need of a referral to an attorney, I will do so for you. My number one goal here is to make sure that you have the information and resources at your disposal so that you can make the best decisions for you and for the estate. Again, please book a call with me. Let's chat. I'm here to serve and support you and the estate in any way that I possibly can. I would love the opportunity to help your family sell a property, whether it's in probate or through a power of attorney situation. So again, I look forward to helping with any of your real estate needs.